Now I'd like to open the public meeting on the nuisance abatement law, and Chief Philo will give us a little background on that, and then we will certainly entertain any questions from you folks. So, great, thank you.
Thank you, good evening. I have prepared a memorandum in support of legislation. In the record.
Okay.
This is a memorandum in support of legislation directed to the members of the town board. It's prepared by me. It starts off with problem identification. The intent of the New Hartford nuisance abatement law is to prevent the degradation of homes and neighborhoods in the town of New Hartford by holding property owners and residents accountable for individuals residing in homes where nuisances are occurring. Nuisance conditions can drive down adjacent property values and have a domino effect on the property conditions in the entire neighborhood. Municipalities have recognized that these conditions are frequently the precursor to more serious problems that can inhibit a community's economic vitality. New Hartford has a significant older housing stock, and many of these older homes have been divided up into apartments. In many cases, the property owner does not live in the house and may not even be aware of the recurring violations of the law. New Hartford also has several mobile home parks where the mobile home is rented out. A significant amount of unlawful activity is occurring in residences where the property owner is not present and may not even be aware of the nuisance conduct by those residing at the property. After several years of noticing an increasing amount of nuisance crimes at rental properties, I requested that the town board authorize the formation of a nuisance abatement committee, otherwise known as the Property Maintenance Task Force. For the past 2 years, members of the task force examined the scope of the problem, reviewed existing laws, and examined current nuisance abatement laws in other communities. It was determined that the best course of action would be to recommend to the town board the enactment of our own nuisance abatement law. To that end, the committee, with the assistance of the town attorney, worked on several drafts of the law, finally settling on the draft before you. There was a significant effort on behalf of the task force to ensure that the law would be fair, provide for due process, and hold up to judicial review. The New Hartford nuisance abatement law represents a community-based strategy involving a comprehensive, multi-agency approach to nuisance properties. This strategy includes 3 basic components: law enforcement, police and courts, prevention and deterrence, and intervention. 4 fundamental principles underlie the New Hartford nuisance abatement strategy: collaboration, coordination, community participation, and leveraging of resources. In addition to units of government, the nuisance abatement law seeks to partner with property owners in dealing with problem residents or tenants. The law includes a formal property owner notification procedure to make sure the owner is aware of any problems. Due process is provided at several stages in the law, wherein property owners are provided with a hearing should the nuisance not be properly addressed. This hearing allows for a free exchange of information between the property owner and town official in an effort to work together to mitigate the problem. Eventually, if the designated nuisances are not resolved, the law provides for a remedy in state Supreme Court, another step in procedural due process. I believe that the proposed New Hartford nuisance abatement law is an example of proactive as well as reactive government. The real benefit of the ordinance lies in its deterrence value. If property owners perceive that there will be a cost to them for allowing continued aberrant behavior, they are more likely to move towards correcting that behavior before it comes to the attention of local government. Essentially, the ordinance will provide, I hope, for property owners who will be stakeholders in their own neighborhood, and therein lies the real purpose of the ordinance. It is important to remember that the nuisance abatement law can also be an important tool for the property owner who may be seeking solutions for problem residents or tenants. It provides them with a means to partner with local government and the courts to correct a problem they might have difficulty dealing with on their own. I would respectfully request the town board give due consideration to the proposed ordinance provide us with the tools necessary to keep our neighborhood safe and ensure continued quality of life for our residents.
Thank you. Now I'd like to open it up to public input or questions of Ray or any of us on this new law. This is, of course, Ray, this has been going, this study into this goes back for about 2 years now?
That is correct, 2006.
Yes, and you've talked to various communities that already have it.
So we've talked to them, we've obtained copies of their ordinances, we've done some site visits, met with other communities and their council who have nuisance abatement laws and are using them effectively. Even communities we found in our research much smaller than Hartford, the town of Shenango has a nuisance abatement law. And clearly towns of similar size and larger towns like County also have nuisance abatement laws.
Thank you. Any comments, input on this? Yes?
Dave Valentine, 30 Pearl Street in Hartford. We have had a problem for 1.5 years with nuisance of rental property where loud parties going on. Some of them start 2 o'clock in the morning, go to dawn, and barking dog, bonfires, leaking gasoline tanks where we had to have the fire department come because my garage was filling with gas fumes and the vehicle being parked next to it. And the police had responded. The last incident was, I think, 5 or 6 squad cars showed up. They could track down a stolen car out of Newburgh that ended up at the residence. And I'm most highly favorable to this. We've got a nice residential area. I've been a resident at this location for 40 years, and the neighborhood has been very stable. But if you allow this type of property to fall into disrepair, it devalues the properties of the rest of the neighborhood and so on. So I wholeheartedly encourage you to support this.
Thank you, Dave. Chief, any comments on that? This would be a classic example?
This would be a classic example. It's occurring much more than it used to be, because like I alluded to, a lot of our older homes in the last decade have been divided up into rental properties. And many of those properties have absentee landlords. And just to be fair to the landlords, they may not even know that they're having problems at their properties. That's why the nuisance abatement law was written, so there's a formal notification process. So, and I've talked to some landlords, and so some other members of our committee, and when they're fully aware of the law, they can see that it can actually benefit them, not only to notify them, but to help them deal with problem tenants. It's not easy. Anybody that's a landlord here and owns rental property knows that it is not all that easy with our tenant laws to evict a tenant inconsistent with the lease. And this may very well be of assistance to the tenant who is trying to evict, or be of value to the landlord who's trying to evict the problem tenant.
Chief, could you maybe give us a scenario, perhaps, how something might start with a noise complaint and then something much more serious involving a felony or something? Give us a scenario on how this would flow.
Okay. Obviously, under the law, there could be thousands of ways and different incidents could occur. But I thought I would talk about a situation that occurred several times in the town in the last year, having to do with sale of unlawful drugs, having to be marijuana. A number of cases, probably 6 or 7, the United County Drug Task Force and my staff dealt with sale of marijuanas out of rental properties in the town. This type of behavior can often lead to other disorderly type behaviors and even more violent behaviors. So a scenario might be that there's a renter who is selling marijuana out of a rental property. The police do an investigation. Usually they're pretty long and protracted. They get the search warrants from usually a county court judge, and they execute the search warrants and make the arrest. Okay. They, at that stage, the arrestee goes into the criminal court system, and the landlord, especially if they don't reside in the immediate area, or maybe they don't read the paper or whatever, they may not even know that there was drug dealing at that house allegedly, and that there had been arrests there and search warrants executed. So we would initiate, after that scenario, we would initiate a formal notification process. It would be in writing, either personal delivery or certified mail, that this incident occurred on the property. We, at that point, can make a decision whether to petition the person in before the hearing board, which is articulated in the legislation. And at that hearing board, we can hear evidence in the civil proceeding as to what occurred there, and also hear evidence from the landlord should he wish to present some. Then the hearing board could make a recommendation to the town board and to the tenant, or and to the homeowner about what we'd like to see done to correct the problem at this particular. Could be we to evict or move to evict the residents. We could probably instruct them that they need to do a more comprehensive background search on their tenants before they lease to them. Or we can, if they don't agree with that, we can move on with the recommendation of the town board for even more stricter penalties against the landlord. I don't see that happening like the first time there's an incident. I see the landlord saying, oh my gosh, this is happening on my property. What can I do to correct it? Thank you for advising me of the situation and providing me with perhaps some alternatives to mitigate that problem, like say eviction.
But they're formally notified of an issue.
Yes.
And basically, it would be up to them. They might initiate action without any further action on the board's part, or the police department's part, or anyone else.
Absolutely.
But now they've been notified of an issue.
They've been notified, and if they do go before the hearing board and we hear evidence on the alleged violations of the law, usually there are more than one, we can make recommendations to them as part of the hearing board and pass them on to the town board. And like I said, the recommendation can be as simple as, if you need to, we'd like to see you
Be more careful.
be more careful, or move to evict the current tenants that have caused the problem, in this case, drug dealing in the first place. The problem with drug dealing, I'll tell you, quite frankly, is it seldom stops at drug dealing. When drug dealing occurs at a particular residence, what happens is violence soon follows into drug dealing. You have drug rip-offs, you have territory issues between drug dealers, and then you start having the violence, the robberies of the drug houses, and God forbid the shootings and whatever. So what can start off as a little marijuana dealing, and once it becomes known that there's a lot of money in that house for drugs, it's quite often can lead to drug rip-offs or rip-offs of the money. So once again, drug dealers, even what we refer to as minor drugs like marijuana, can often lead to violence. And once again, I just use that example because we had several of those this past year. We can deal with continued nuisance parties.
I think that's another,
Yes,
the extremes that we know of, but simpler stuff.
Yes.
Nuisance parties.
Here's what happens typically. Every weekend there's a party at this house. There's a nuisance, meets the definition of the nuisance abatement law. We go there. Traditionally what you do is you knock on the door and say, look, we got a complaint, you got to quiet down, it's 1 o'clock in the morning. If they don't quiet down, we come back and we make an arrest for disorderly conduct, which is a violation under the New York State Penal Law. It has the same weight of a traffic ticket. So they get arrested. We do our job to the extent we can. But maybe 2 weeks later, they have another loud party. They have another party or disorderly gathering at the property at 1 o'clock. We can only do so much under the criminal laws. The nuisance abatement law actually can bring them in, but more importantly, can bring the rental property, bring the landlord into the mix to say, here's what's going on. You need to do something about it. You need to be a stakeholder and a partner in this community. And if they need the eviction or just corrective behavior or a warning from the landlord, every case is going to be different.
Yes, sir.
I'm Brent Whittington, Marshal's Office, Utica, New York. We're part of the nuisance abatement team in Utica, and it's the mayor's office that calls us when the landlord's been contacted through the nuisance abatement law that you speak of. The landlords call us to prepare and serve the papers on the people to throw them out. We also can help them to, well, help you to see if you can find some better tenants. We have records showing what tenants have been brought to court in the past regarding situations like this. But we've come tonight just to lend a hand in that. I just wanted to let you know that.
Thank you very much.
So that data would be available to a landlord?
Correct.
Thank you.
There's a lot of also, you make up a good point, there's a lot of commercial services that might cost a few dollars that you can actually investigate your prospective tenants. And we probably would want to encourage that behavior, or maybe the hearing board could demand that type of behavior, or that type of practice with our landlords. I think it's a great investment, or a great process that any landlord should engage in, is to investigate their tenants. And I don't mean a criminal investigation, although it could include that. I mean past financial problems, past tenant problems, being evicted, other civil issues with this particular person.
Actually,
Whether they paid an IMO bill or National Grid bill and all those things, it's a pretty good indication that they're probably not going to pay their rent. And the landlord might say, well, I'm decided not to rent to this person. So those are great suggestions.
In addition to that, there's Utica landlords have formed a sort of a coalition that meets once a month at City Hall there. And I know that a lot of the tenants that you're probably having problems with in New Hartford are coming from Utica. They meet there and they give a list of all the tenants that have been evicted for free every month. The next meeting is the 25th at City Hall. It's 6:30, I believe, in Utica. But if you go, you can pick up a list for free, and it'll show you all of the tenants for the last 6 or 8 months, maybe, that have been evicted for various reasons, have been brought to court with a petition.
I might add, Utica is one of the nuisance abatement law we looked at, as well as the city of Rome. Both cities have done a great job in dealing with their problems. I'm sure that 10 years from now, you'll look back and say, because your nuisance abatements are relatively new, like
Correct, yes.
5 years, I think.
Yes.
Thank God we've had it. What condition would we be in now if we didn't enact it 10 years ago? Right?
You'd be renting to the same people over and over again.
Yeah.
I appreciate your input, and that's a good cooperative measure. You can use that. I notice I'm a runner, so I run through West Utica, how that's changed so dramatically from ethnic neighborhoods now to mostly rental properties, and so it's interesting. But there's a lot of action, unfortunately, in West Utica.
Yeah, I'd just like to remind everybody, we have a large older housing stock. I think a lot of people who don't live here think everybody in Hartford lives in a new home, but we've got a large older housing stock. We don't have large families anymore. These homes have been bought up and divided. We've got several trailer parks or mobile home parks where the trailers are being rented out. And some, quite frankly, some of the people living in these particular places are, shall we say, problems.
Do we have any more comments, folks? Yes. Yes, ma'am.
Mary Strolsky, 37 Slaughter Ave. The first thing I want to say is that it's a long time in coming, and I hope it comes soon. We have 2 such properties across. One is on the corner of Esmeralda and 37 Slaughter Ave. And right now, that is more or less has become a frat house. There are at least 4 boys living in this house. Cars are parked directly in front of the house. They have their parties just about every Saturday night. The person who lives exactly across from them has cars in front of the house, side of the house, the noise keeps going on. Finally, she called the police on the police phone. It's a mixture. It's a party. Sunday morning, when you get up, there'll be a car parked on the corner of Esmeralda and Wilbur with a beer can on top, standing there. Another one directly in front of our house. Another one up above the plow. Thank heavens we haven't had all that heavy snow, but no way could it really plow the road the way that it should. And New Hartford always has plowed it beautifully. So we have these cars all over. Now the house directly across from us. Everybody knows at home. Everybody in New Hartford knows it. We had drug dealers living upstairs in both of these houses. We even had the FBI come into that house across from us. We had drugs buried in the bank of our creek.
I remember.
Do you remember that? Unbelievable. We've had, and this has been going on since the arterial went through and the town allowed this great big monstrosity of a house to be moved in there, following absolutely none of the laws. It's right about 10 feet off the road. It's a mess. But that's beside the point. That landlord lives in this area. And I think codes has had more to do with that one home than any other probably in the town of Hartford, unless there are. They know these two homes well. Twice we've had this reassessment of properties. Twice our property was supposed to be reassessed. When we went for the hearing, as soon as the people knew where we were living, we didn't even have to plead our case, because this has been going on and on. So I guess I'm setting up. But what I'm saying is there are two properties that are so well known for problems, and I can't tell you the people that it is on these homes.
Mary, we're gonna pass this law tonight, hopefully, and this will, put some teeth into it, so that you should have it at your point in your life. I know you're probably going to church and you have to see that beer on a Sunday morning.
Well,
You know,
I don't mind the
it's probably a little It's not a community club.
The area was a very quiet.
That's
little
right,
area.
and that's why you had a classic example of what we should address, and hopefully at the end of this public input from folks, we're gonna pass this law so that the chief and his folks will have the teeth in this law to address that situation, which is horrible.
And you just don't feel as if you're going to say anything to these people, you don't want to get involved with this. You're a little tired of calling up, complaining about it, but it's constant.
That's right. We hear you. Thank you very much, Mary. There's another gentleman.
Ross Sloan, 2 Woodland Road, former police commissioner, when my problem happened. But we had a house across the street, 2 families rented out to Eureka College students. And it was all women that were renting in there. And we had a constant traffic problem with boys coming in and terrific drinking problems. These guys would come in and take cases of beer out of the car every night, and they'd be all over the street in the morning. And the noise was terrible. And Ray knows, because I was on the commission at that time. And he knows the problems I was having, because I was telling him that I was calling up to get somebody over to quiet him down. The way it was solved is that we went through Eureka College, and Eureka College put pressure on the landlord, who happened to be a trustee there, I believe, and he got rid of them. But they trashed his house, too.
That's all.
He's not ready to do those again. But it was a case that Ray was talking to me about the abatement law that you're talking about right now, and I think it's an excellent idea to eliminate that kind of problem.
Thank you, Ross. Gentleman right here.
Yes, sir. Roger Gatto, I live on Urban Ave, and I'm over there, I've been there for 10 years, I bought my mobile home back then, and the rest of them are rental properties. And since then, they've all deteriorated, not only the homes, but the people living there, and now the drug activity and everything is just, it's rampant, especially 2 mobile homes in particular. I've made numerous complaints, not only on the deteriorating homes, but of the activity, and it's just, and there's, it seems like the first 2 weeks of the month, especially when this goes on at night, and there's, like I say, the drugs, I know of one place where it's manufactured, and it's just ongoing, and I'm planning to move, but in the meantime, anybody else that goes there, it's just, now the new person that bought the property lives in Colorado. And then there's these wild basketball games, these mobile homes are close together, mine's on a corner lot. One gentleman had his windshield broken out by this one individual that persists, and there's 3 or 4 cars on the side of the road all the time with 10, 12, 14 people, and that's a nuisance with the ball, and it's constant and every night. I don't know if that would be considered a nuisance, but to myself living there,
I think it is.
I mean, it's constant.
First of the month, huh? That's interesting.
Oh, yeah.
I wonder why.
Exactly.
Yeah.
In all hours of the night, you see these cars. This mobile home in particular is 2 down from me, and the cars in and out all hours of the night. I've seen it. You can hear the doors shut. At the parties, you just start open fires, constant.
Thank you, Roger. And so you're definitely in favor of it.
All
All right, good. Thank you. Ed?
Yes, I'm Edward Bradley, and I live at 25 Paris Road, just up the street here. The question I have is, what if the landlord, my landlord is an absentee landlord, however, he is aware of problems that are happening in one of the apartments in my house. Ray probably knows of some of the problems that have happened in my house. What happens then if the landlord is aware of it?
We still go through a formal notification process, and then we can call him in before the hearing board.
Because he actually, the last time that there was an issue, he actually came to me and said, kind of be aware that.
We would still formally notify them of the problem, so they can't say, I didn't know. Even though I suspect a lot of landlords know or suspect and just turn their heads as long as their monthly check comes. Maybe that's unfair, but
Yeah.
I suspect that's occurring.
Yeah.
They would still get a formal notification problem of a particular problem or a series of problems, and we would have them come before the hearing board, and we would hear evidence on the nuisance or nuisances. And the nuisances, by the way, I made a bunch of copies, there's still some of them that are clearly articulated right here in the law. So we would still be very formal with them, with whether they knew or not in terms of their knowledge.
So would a basketball, a big tight game going on in close homes, would that be considered a nuisance?
It could. And here's how it becomes a nuisance. And it's subjective, not always objective. What's a nuisance at 2 o'clock in the morning is not a nuisance at 2 o'clock in the afternoon. So once again, it's based on a reasonableness standard. Kids playing basketball at 2 o'clock in the afternoon is probably pretty acceptable to all of us, depending on the variables. But people playing basketball at 2 o'clock in the morning is not. And that may push it over into being a nuisance.
Okay, one more question on the known drug activity. If one was to report it, you gotta have proof and everything on
No.
this, or how would that work? I've never had
No.
the will to do it, but now I do.
In Oneida County, we're lucky. We have a Oneida. What occurred is the law enforcement agencies in Oneida County 10 or more years ago recognized the best way to fight the drug problem is multi-jurisdictional. So we created a county drug task force under the district attorney's office. So even suspected drug activity, if you get it to the police department or directly to the task force, your local police department, whatever community you live in, you don't have to have probable cause, you don't have to give statements or anything like that. But if you give them enough information about what's going on, and they ask you to get some plate numbers if you're in the interview, they can open a case file and then do whatever they have to do. I've seen my people work on drug, assigned to the task, work on drug. It took them 2 years to build a case. So sometimes it happens in 2 weeks, and sometimes it takes 2 years. It's all very specific, and it goes from surveillance and observation into perhaps wiretapping and into search warrants, and then the culmination of the arrest. So it's not always easy to build a drug case, but the bottom line is if you give the information to us that you suspect this type of activity, we will open a file.
Oh, really? So all it takes is somebody to...
Yeah.
Right.
You can't just say, I got 2 young people living in that apartment next to me, and all young people do drugs, so therefore, they're no drugs. You can't
Right.
make those type of assumptions and whatever, but if you give us some reasonable grounds to believe, we can direct you on what information you need, then we can open a file on it. We've done it many, many, many
Well, the
times.
person who stopped in at the...
Stop in or call.
There's confidentiality.
Absolutely.
That's always been a concern in the past.
Yeah, but there's confidentiality, Roger, so that and we have, the drug task force is probably one of the most successful team efforts
We use it
in Oneida County.
almost daily.
It's
I do know,
done
no
great
offense,
things.
there are weapons in these 2 mobile homes where this has been going on.
We,
I'm not even worried about retribution.
yeah, I know exactly what you're saying, and I think that Ray would know how to handle it.
As a landlord, to know exactly what we're supposed to be looking for. I don't wanna be called in on something that,
Those,
Like it's happening.
those refer to certain sections of our local ordinance Chapter 56 happens to refer to dogs and pets. We have certain laws on the books regarding dogs. They actually mirror state laws.
And as a landlord, could that be provided to us?
Absolutely.
All of this that we need to know?
Absolutely.
Okay, and another thing, if, say something does happen in our property and we don't know about it and we're called to a hearing, is our name gonna be used publicly in the papers?
Well,
Without, I mean,
we don't intend to make press releases on the nuisance abatement hearings or anything else, because a hearing is not so much an accusation against you. The hearing, the notification and the subsequent hearing is to bring you before the committee, nuisance abatement hearing board or committee. We can present you with the issues at your property if you're a landlord, and then you can subsequently tell us what maybe you want to tell us we're wrong,
right.
or present evidence on your own behalf, or say, well, geez, thank you for letting me know, and here's what I will do about it. And we can
Right.
revisit the issue.
And it's good, and we can work with you, but I just, sometimes it just seems like, we don't want to be the bad guys
Yeah.
completely either. We need help too.
I-
So, and sometimes when you try to be very careful in selecting your tenants, and you ask for references, they can lie to you too, and they can tell you they're gonna be the most wonderful tenants, and you check their references, and sometimes they lie to you too, so we need tools.
Yes, that's why we decided to make this a civil proceeding and not a criminal one, like violation of a town law, so we're gonna issue an appearance ticket, and you go tell it to a judge. We made this a civil proceeding. We built in a lot of due process. We wrote this law 5 or 6 times, Jerry rewrote it, to make sure due process is in here, fairness is in here, because our interests are in helping the landlord correct the problem, if it happens to be a landlord-tenant situation, correct the problem, not making life difficult for you.
So we can actually call, like, say, who would we call if we wanted to find out all this more information? Would that be available someplace?
You mean the actual
Like,
sections of the law?
yeah,
You can
sections.
call my office, you can call the town clerk's office, you can call the codes office. All of us have the code books. We can photocopy any section out of it for you. Yeah, that's,
Give them the website address,
Give
they
them-
could access it.
you can access it from the website. Yeah.
Right.
As a landlord, you should be commended for being here and asking the questions. I think that's wonderful. I mean,
Not
it
all
shows that
tenants
you
are
want to
local
be
tenants.
involved.
Yeah.
I'm sorry?
Not all tenants are local tenants.
That's
People are
correct.
transient, they come from across the country.
That's right.
You might be renting someone from California.
Right.
And you can call and find out references, but who knows?
No, you're 100% correct.
Some leases, I call them leases, they are because they're verbal and they're month to month. Which I was kind of surprised at when I started to do research and talk to our judges regarding landlord and tenant cases they've had before them. There's a lot of tenants out there that there really isn't a lot of history on, and they go month to month, and there isn't a written lease, it's verbal, the verbal lease.
Christine, did you have something you want to say?
Yes, Chief, I get several calls on this, and most of them were agreeing to it. I did have a couple people though who were concerned, and actually they weren't landlords, they were single-family owners, homeowners. And they have a problem with some of their neighbors where their neighbors just complain about everything, One gentleman said that, he's retired, in the summertime he likes to go between his garage and his yard and be puttering around, and he plays his radio and his neighbor keeps calling off, And, how are you going to kind of address it from that stance?
Well, first of all, the nuisance has to rise to the level of the nuisance articulated right here in section 86.2. And I'm familiar with those type of situations, and they occur quite frequently where one neighbor doesn't like another neighbor, so they sort of use the government, i.e. the police or codes, as a method to get even with it. We deal with that currently now. I think we deal with it. It has to rise to the level of the violation. Sometimes that's subjective, like I said, and not objective. That's where we rely on people like myself who was experienced with the law, the town attorney, to say, wait a minute, this doesn't rise to that level, and we're not going to take, and the nuisance abatement law doesn't apply. But you're absolutely right, we have to be very careful about not being utilized in that, the law or our resources being utilized in that fashion. It doesn't occur.
I have a question. I am a landlord too, and sometimes
some of these tenants who do come in with very good references, but once they're in, they turn around and you virtually can't get them out. And sometimes people don't see you're trying, you're taking them to court, you're doing what you're supposed to, but as a tenant, they seem to have a lot of the rights on their side once they're in. And some of these people, let's face it, they know how to get around and how to hang out in place as long as they can. Will you also be offering the landlord's assistance in helping to get these people out? Because sometimes we feel our hands are tied and judges let them stay.
To the extent the law allows, absolutely. And you noticed in my memorandum in support of legislation, I kind of addressed that a little bit. And here's an example you could do as a landlord. As part of your lease, you can put, must adhere to the provisions of the New Hartford nuisance abatement law, section 7. Put that right in, and that's grounds to go to the court on an eviction hearing that they violated the tenant of the lease. And that's one of the things that was pointed out to me that I actually didn't look at originally, that could be very, very beneficial to a landlord. And this isn't what you have, this isn't once you have a problem tenant, this is all tenants. It should be right in your, you can even put this right in your lease. Therefore, once again, if they violate, if they become nuisances, you bring them to an eviction hearing in your local criminal court, in this case, the Hartford Town Court, violating the lease because you created a nuisance. The tenant created a nuisance. And I thought, my gosh, that's an innovative approach to using this law to write in to a lease. And actually, an attorney suggested that to me, talking about this. So I thought, my gosh, that's very positive for the landlord.
Thank you. If there are not any other comments, I'd like to call the meeting. Yes.
Earl,
Yes,
I gotta make a couple comments. They wrote a couple things down here. Randy Bogar, 71 Cheryl Lane. My initial concern was what was in the law, but after I've read it, I think those concerns are no concerns anymore. And I can support it. I think it was said here, the trick is to find good tenants, you know, and we've all, I'm a landlord also. We've always had a lease, and we always do references, and something that we check now at work, there's 2 websites, and I don't have them with me, sexual offender registries that you should be checking too. You'd be surprised what's out there. So I would say that whoever's a landlord, you ought to be checking those things as well. I can support it, and I'm glad that Chief Philo, that you didn't include all the landlords in your initial comments.
I was very careful
in the same group.
Try to be fair.
Because I haven't had a problem with any of the tenants, but it's because we're careful on who we get in there. And I think that's the key.
That's the key, absolutely.
Absolutely.
Thank you, Randy.
Oh, I'm for it.
Good. Do you have any additional comments? If not, I will call the meeting closed.
Yes, I'll make a motion to close the hearing.
All in favor? Aye. Therefore, we can now vote on the law. Chief, I want to thank you so much, and Jerry, there's been a lot of work on this. This is not taken lightly. And,
Thank you. I was remiss in not recognizing the Property Maintenance Task Force was created consistent with the recommendations of the Municipal Conference of Mayors. So we kind of had a template on how to proceed with this, and I'd like to thank the members of that task force. I'd like to especially thank Jerry Green, who worked innumerable hours on this, in drafts and redrafts and rewriting. Once again, just to make sure we had due process and the law was fair.
And I think it's interesting for landlords that they can incorporate this in your lease, which I think is an excellent idea, Chief. That's a very good point to have. So I thank you again for this, and we're not out to punish landlords or anything, but I think it's just it's well needed, and we've obviously had some activity in certain areas in the town. So I think everyone's been presented. Rich, you've done a lot of work too. Thank you. And I think also the late J.C. Waskowitz was a big factor in this too. So if that being the case, then can we vote to?
I'll make the motion that we'll adopt the local law, public nuisance abatement law.
Made by Rich,
A second.
Second by Dave, all in favor? Aye. Passed. Thank you very much, folks. and
Thank
Thanks
you.
for joining us.
Good to see you. How you been?
Public presentations? If not, Roger, you're next on the agenda. Will you kind of face the folks there a little bit so they can hear you?
Several years ago, the county started a hazard mitigation study. And in order for the county, the towns to continue to receive assistance through FEMA, we need to adopt the hazard mitigation plan that was that we all had heard of. We had a number of meetings. United County Soil and Water Conservation Department basically coordinated all of these meetings, and there's been a manual. It's about 2.5 inches thick that's been prepared, and the county needs to adopt this. We need to adopt it before the county adopts it. And just briefly, down in Hartford, with the assistance of the United County Hazard Mitigation Planning Committee, Soil and Water Conservation District has prepared the United County Hazard Mitigation Plan. There's a couple more whereases. Now therefore be resolved by the town board that the town of New Hartford adopts the county hazard mitigation plan as the town's official natural hazard mitigation plan, and resolves to implement the recommendations of that plan, hopefully adopted the 13th day of February 2008.
You need a motion then on that?
Yes.
Moved by Bob,
I'll second.
second by Dave, all in favor? Aye. Thank you, Roger.
Thank you. Within the past several weeks, I've been advised that we have an issue in the lower part of Oxford Road, just before the crest on the southern part of Oxford Road, with a number of deer that have been crossing. In fact, this came to me through the police chief. And I checked with him, and there has been 25 car deer accidents in this area on Oxford Road. And I would recommend and ask the board if they would authorize deer crossing signs be erected on the southern end of Oxford Road to advise the traveling public of this potential hazard.
It's gonna be past like Snowden Road and Tibbetts going that way, or?
Yeah.
Okay.
And that's 25 car deer accidents within the past?
Since
Long.
'92. That's as far back as our records management, computerized records management system goes.
No, I'm happy to move that.
All right. Moved by Bob,
Second?
second by Rich, all in favor? Aye. Thank you.
Thank you. Request permission to attend the University of Wisconsin-Madison Conference on Sewers from March 17th through 19th. This will cover sanitary sewer overflows, maintenance procedures, and fixes on our sewer system. I attended one of these a few years ago on fats, oils, and greases, and we've had very little problems since we've implemented some of the recommendations from that.
Is it Madison?
Pardon?
Madison, Wisconsin?
Wisconsin-Madison.
Yes. Good.
It's in the budget.
Not bad.
Second.
Moved and second, all in favor? Aye.
Thank you.
Just want the individual who brought the concern about the deer crossing, do we have a telephone number, do we have a contact? that we can-
Councilman Reynolds has the.
It's just not here, so we can just advise them that,
Yes,
okay,
I'll give it to you.
thank you.
Okay.
Next issue is engineering services agreement. This is for the Hartford Insurance site, which is currently under construction, and the park, business park development. These will be three-party agreements to be paid for by the developer to ensure that there is compliance with the approved plans and specification. And we have one for the Hartford site, which is in the amount of $7,500, and one for the park development itself for $14,400. and I would ask the board to move to approve those. We will then send those out to the developers for their signature and Shoemaker for their signature.
They pay for it.
Right.
All right.
I'll move.
Moved by Christine, second by Bob. All in favor? Aye.
Thank you.
Thank you.
I have a resolution with me here. Consumer Square. Seems to have drifted something there. As you know, the town has been concerned with the traffic flow, both ingressing and egressing the Consumer Square Retail Center. And we have met with the owner of the center, a number of town officials, and in order to define and quantify the improvements, the town has met with them, with the owners, and to develop the criteria, the options, and the improvements that could be done. Asking the resolution be passed. The agreement with the property owner is to allow Benderson to reduce its $100,000 bond, which the town currently holds, and or letter of credit with the town on the Consumer Square project by $16,500, with the understanding that Benderson will pay $16,500 as and for the Consumer Square Center and intersection traffic study to be performed by Clark Patterson Lee as outlined by them on a letter dated January 10th, 2008. Upon proof of this town board approval, Benderson is to provide the town planner with proof that the subject bond and or letter of credit has been reduced to $83,500 and a check made payable to Clark Patterson in the sum of $16,500 to be held in escrow by the town pending the town's acceptance and the completion of the study.
Okay.
So we end up still having $100,000,
Now, the bond will be reduced by $16,500.
but the 16 goes in escrow, you said?
The
Is that a
16
misunderstanding?
comes to us. We hold that amount of money until Clark Patterson does the study,
Right.
and we're satisfied with it.
You think we're protected, Jerry?
Yes, the group that met, Rich, recognized that holding Benderson's feet to the fire on some unfinished business up there may not be the most prudent thing to do. The study's needed, and the town didn't want to pay for it. And while the bond or letter of credit serves as protection or some insurance against site development, it would appear that there's consensus among Benderson, the landowner, DDR, and town officials, staff, that this is a good way to spend the money to find out what the problems are, see within what Benderson will do, what DDR will do, what the town can do, maybe DOT, and then hopefully work on a comprehensive fix up there rather than something small and insignificant.
Right. We didn't want to start recommending certain fixes without having them looked at first, and then wind up having the fixes made and still have an issue.
Okay. Any questions of Roger? If not, could I have someone move on that motion, please?
I'll move it.
Moved by Dave.
I'll second.
Second by Rich, all in favor? Aye. Thank you, Roger.
Thank you.
Jeff? You're next.
Okay. Just got a quick thing, well, not so quick, it's a civil service appointment for a part-time dispatcher to replace another part-timer who was left. She's on full-time up at the county. And this has all been approved through personnel and civil service. We've got the paperwork filled out. It's a gentleman off the list and requesting an appointment for the contract starting hourly rate of $10.66 an hour. Again, this is filling a vacant part-time position, existing position, and he has been taken off the civil service list, interviewed, reviewed, and gone through an extensive background check, which he's passed. And due to our lengthy background check, the first when you get these lists from civil service, they give you a 60-day window to act on the appointment, and we missed that window with the background check, so Barb went back to United County Civil Service to get him reapproved, and to meet the approval of County Civil Service, I'm asking for an appointment for a part-time permanent position, but it needs to be retroactive approval date of January 25th to meet County Civil Service guidelines.
But he hasn't started.
He hasn't started yet, no, he'll be starting, start date of effective February 18th. And his name is John Libby, he's off the Civil Service list, and again, all approved by County Civil Service.
And why does it have to be,
Well, they're in the process, they had a test in the fall, and he was on the existing list, and they're establishing a new list that he is not on, because he was being interviewed, and so we have to go retroactive date-wise to get him approved by County Civil Service, which they're aware of, and they've asked us to do that.
okay.
Okay. Any other questions? Jeff? Not? Move on the appointment for the part-time. Moved by Bob,
I'll second.
second by Christine. All in favor? Aye. Thank
very
you.
much. I'll leave
Chief?
the paperwork with Gail.
Maybe a couple of agenda items here. First is, I would request the board pass a resolution authorizing the town supervisor to execute an agreement between the town of New Hartford and Stephen Swan's Humane Society entitled Animal Sheltering Agreement for 2008. This has been reviewed by both my department and the town clerk. Both of us have a lot of dealing with the Stephen Swan's Humane Society affecting our animal control duties here in town.
Moved by Dave,
I'll second.
second by Christine. All in favor? Aye.
Second, we have a full-time vacancy in the police department. I would ask the town board to approve Jared Petrie to fill that vacancy. It would be off the United County Civil Service list. Currently part-time.
Okay.
He's moving up to full-time.
That's correct.
Is somebody left? the full-time
Yes,
list?
this fills the vacancy created by Stephen Snyder.
Okay. I'll move that. Moved by Rich,
I'll second.
second by Christine. All in favor? Aye.
I would request the appointment of Patrick Sacco, S-A-C-C-O, to replace Jared Petrie as a part-time police officer. Both of these gentlemen, by the way, are certified, which saves us a significant amount
Is he coming from another department, or is he?
of. Yes, he's coming from the village of Frankfurt.
I'll move it.
Moved by Dave,
Second.
second by Bob. All in favor? Aye.
Thank you.
Thanks again for a great presentation
Oh,
tonight.
thank you.
It was great, and he's very enlightening, too. Town clerk?
In behalf of the planning board members, Hans Arnold, Roger Reynolds, and Robert Wood, we're requesting approval to attend the 19th annual local government conference in Watertown in March. We need your permission.
Fine.
I'll move.
Moved by Christine,
Second.
second by Bob. All in favor? Aye.
Okay, on December 28th, the board did adopt a resolution allowing me to attend any records management conference or training session, and there will be one on March 10th, it's a half-day session that I'll be attending in Utica. Further, I would like permission, and it is budgeted, I do have enough money, I would request permission for Melody Fanslet, Deputy Town Clerk 1, to attend the New York State Town Clerks Training Conference in April.
Move that.
Second.
Very good.
All in favor? Aye. Congratulations.
Bob and who? I didn't get who
Dave.
seconded.
That's
Dave?
right, Dave.
Okay.
Where's that conference?
It's in Saratoga.
Saratoga.
How's the job going?
Very well, thank you. I love it.
Good.
Okay, just to note, in the last minutes, there is a resolution that, on purchase of highway equipment, and the standard resolution had been for years, that permission was needed from the United County Department of Public Works in order for the town to purchase this, and we always sent the contract for their approval. I had heard through some clerks that this was no longer a requirement, and so I just wanted for the record here, for audit purposes, in case anyone questions, any future resolutions will not include the approval from the county because the state highway law has been changed, and it no longer requires approval of the county Department of Public Works. So I just want to make that. I think that's it. Oh, no, it's not it. I'm sorry. Did you have a question?
No, thank you.
Oh, okay. Just to make you aware, I did receive an appeal today under FOIA law from a gentleman who wished to photograph some records. I don't know the circumstances. I've asked, if perhaps they were not disclosable records. I don't know, but I'm asking that the department head and perhaps the town attorney advise in writing the denial of the individual to photograph the records. Because by law, they do have the right to use a digital camera, and I do have a copy of Robert Freeman's opinion that was faxed to me this afternoon. So I just need to know if if these records were not a disclosable records, or if the individual was just being denied to photograph the records.
So the department head is looking at it, is that it?
I've asked the department head to look at it and to let me know, put it in writing. Why? Because then I have to let the individual know, and the town board only has 10 business days to resolve this and respond to the zoning.
Is the town attorney involved in this at this point?
Yes, I've been contacted and we've already begun the research.
Okay, good.
And here,
Let's see this one. All right. Did you have something, Dave?
Yeah, just, the voting machine, I know the town doesn't have anything to do with the voting machines anymore, is that correct?
that's correct.
The county took them over, were we compensated at all for those? Should we have been,
I don't know that the state law provided that the counties compensate the towns, villages.
That was done across the state,
Yeah,
the county took them
Right.
over.
right. They became responsible for everything as of November 2005.
Okay, another question, I've been contacted by several people working at the polls, that it's an extreme hardship now to go at 9 o'clock or 9:30, quarter to 10, down to
Train station.
the train station. But we, as a town, are out of the process completely.
Right. And I have emailed the town clerks in Oneida County, and I'm going to put a chart together. Most of the town clerks who responded to me are having they're not bringing the records to the county, the election records, or the voting machine custodian who's assigned to their specific area is picking them up. In one case, I think town of Kirkland, their police department is returning the election bags to the county.
Down to train station.
Down to the train station.
Right. They'll actually meet you out in front.
Just as a side note, we did escort one election worker down this past fall at her request.
I almost think if we could work that out, we should do that, because it's not a good place to be at 10 o'clock at night.
I've been down there, that's right.
Well, just consider that.
And the law that to which Gail's referring does allow the county to enter into an agreement with the town on a whole host of issues, and that could be